Hi, my name is Richard Litvin, and this is my introduction to constitutional law as it is tested on the bar exam, both on the multiple choice portion of the bar exam, the MBE, and on essays in very many states, whose essays I've considered in determining what I'm going to cover today and with what emphasis. The purpose of this introductory lecture, like my other introductory lectures, is to give you a big picture overview with the thought that if you have the big picture, the parts make more sense. The purpose is not to cover every detail, not to go through everything that might be in the long outlines that I ask you to read, certainly not to mimic or cover everything that might be in like the 6 or 7 hour Barbary lecture, right? You will hear those in good time if you're taking the Barbary course. Rather, I'm just trying to give you an overview that helps you focus your reading on what is the most heavily tested and gives you a sense of why you're reading it. That being said, let's start with what is a constitution? That which constitutes something, that which makes up something. And how is constitutional law different from everything else that you look at in your law school career? Different from everything. The Constitution created the United States. The Constitution actually created the United States. The United States did not exist as a nation prior to the adoption of the Constitution. The beginning of the Constitution says, "We, the people of the United States, in order to form a more perfect union, do ordain and establish the United States." Now, this is important to understanding everything that follows. Prior to the adoption of the Constitution, there had been 13 colonies spread out along the eastern seaboard, colonies of Britain, and they had rebelled and said, "We are throwing off the chains of being colonial. We're throwing off those chains and declaring our independence," Declaration of Independence. But they were 13 separate political entities, not one, although they got together in a Congress from the beginning where they made decisions. As the war drew to a close, the 13 separate new sovereigns entered into an agreement called the Articles of Confederation. We are 13 separate nations and we're confederating with each other. But in the Articles of Confederation, the new common government had very little power. It didn't really make a nation. It had limited powers on taxation. It had to ask for money. It couldn't regulate commerce. It had almost no real power. So after a few years under the Articles of Confederation, those who were living under the Articles said, "We need to do more." And so they authorized a constitutional convention, well, a convention anyway, for the purpose of amending the Articles of Confederation, for purpose of amending. And the instructions to the people going to this new Congress were, amend the existing articles and send them to the states for ratification, to the states, to the state legislature, state legislatures of the 13 separate sovereigns, and only if all 13 agreed would these new rules go into effect. The people who came to the Constitutional Convention ignored those rules. They set about fairly quickly in devising a totally new framework for government based on their experience and based on their reading of history and of political theory, which I'll talk about in a minute. And they decided that instead of sending their document to the legislatures of the 13 states, they would send them to conventions to be held by the people in the 13 states. And instead of requiring all 13 to ratify, they would only require up as 9 to ratify for these things to take effect. So this convention created, through a document, the United States. A couple of things going on here. Number one, theories of what makes a government legitimate. Prior to the coming into existence of the United States, many countries in Europe had the notion of the divine right of kings. Kings got their power from God, not from the people, and people had to obey the kings. But there was a growing theory among European political thinkers called the social contract theory, in which they determined that a government gained its legitimacy from the people, not from the king, not from God, but from the people, entering into a social contract, giving up some of their freedom in order to have a government that would be legitimate. John Locke being one of the major proponents of this social contract theory of government, and of course John Locke is someone who all the founders had read. But not only did they decide that they were going to have an actual rather than a mythical social contract, but they also were influenced by a couple of thinkers from the previous century or two. One, Philippe Orlik, a Ukrainian who tried, without success, to institute a government that separated powers in a way that we are all very familiar with today, that set up different branches of government with different authority, divided that power, and expected that in the clash and working out of things, that would help limit the government, help control the government, as opposed to the divine right of kings where the king is absolute. Well, Orlik failed to get this instituted in his homeland of Ukraine, but the idea was picked up sometime later in France by a famous philosopher named Montesquieu. So Montesquieu is also talking about the separation of powers. Along comes the Constitutional Convention, and they develop this contract, and they send it off to be ratified by the people who will be forming a government under this contract, and they use the separation of powers as a critical part of what they did. So that's important as background to what's going on here. We're setting up a government of limited powers, powers given by the people in this social contract called the Constitution. That's very important, okay? Now, one of the implications of that for you as a lawyer, law student, bar taker is this. Anytime the federal government, any part of the federal government, any employee, any agent of the federal government does anything, that thing has to be grounded in the text of the Constitution, either expressly or by implication and development over time in history. But the powers of the president, of Congress, of the judiciary, the powers of the people working under the president, the Secretary of State, the Secretary of Labor, and all of the people under them, and the Federal Aviation Administration, and all the FBI, whatever they are doing is exercising a power given to the federal government by the Constitution, either expressly or by interpretation over time. Anytime you see a federal actor, think, where did they get the authority to do that? Because they don't have the inherent total authority of a sovereign. They don't have what is called the police power, the power to do anything that they view as being in the public health, safety, welfare. They have limited powers. That's one thing that comes out of this whole approach to this new Constitution. Limited government. Now, let's look at the big picture of the Constitution. If you've heard my lectures in torts and contracts and evidence, you know I really find it very useful and helpful, and I hope you do, to see things in a big picture way rather than just here's a rule, here's a rule, here's a rule, here's a rule. Big picture at the beginning so that now things later will make sense and fit in. So my big picture for the Constitution, as you will see, hopefully I will have done a slide and put it up on the screen, is this. All of the law of constitutional law divides into three basic parts. The powers of the federal government and the division of powers, the division of labor between the legislative, the executive, and the judicial branches. Separation of powers and separation thereof. That's first big topic. Second big topic is what is the effect, sometimes explicit but very often implied, on the pre-existing states. The Constitution is adopted. What effect does that have on the states? What relationship is supposed to exist between this new federal government and between the states? This is what we call federalism. All the rules pertaining to the impact of the existence of a constitution on the states will put under the label of federalism. Second big topic. And third big topic In the original Constitution, there were a few specific individual rights to be protected against the government. Very few in the original Constitution. There was neither the states nor the feds shall pass any ex post facto law, neither the feds nor the states shall pass any bill of attainder, whatever the heck that is. States shall not impair the obligation of contracts. There are only a few things in the original text of the Constitution that create individual rights against the states or against the federal government. But very shortly after the adoption of the Constitution, the Bill of Rights. In our history, looking back at history and not spending too much time on it, I trust, the Jeffersonians distrusted the government and said, we need protection of our individual rights against this new government, lest this new government become too powerful, lest this new government become tyrannical. So they said, we will agree to entering into this social contract, but on the understanding that we are going to have a Bill of Rights shortly thereafter, and a Bill of Rights was promoted and adopted shortly thereafter, Amendments 1 to 10. Not going to talk about the details right now, but here is a series of rights protected in the Bill of Rights. And it says, Congress shall not restrict the freedom of speech, shall not establish a religion, and so forth. Congress shall not. But in the period of time after the adoption of the Constitution, the question arose whether the Bill of Rights could be enforced against the states. And in a case in, I believe it was 1832, Barron against Baltimore, the Supreme Court said, no, the Bill of Rights applies only against the federal government, which is to say, if, let us imagine, an abolitionist. See the movie, the recent movie about Lincoln. Let us imagine an abolitionist bound to see slavery abolished, or to go to South Carolina and get up on a soapbox and say, slavery is the work of the devil, slavery is evil. What would happen? Probably in South Carolina, he would be chased by a mob and tarred and feathered and maybe even thrown in jail. And he would bring a lawsuit in a federal court saying, protect me. I have rights of freedom of speech. And the short, sweet, simple answer was no. You don't have any rights against your state government based on the Bill of Rights, only against the federal government. So the states are free to deny people inside the state freedom of speech, freedom of religion, all those other things. So we have the Bill of Rights creating a set of individual rights enforceable only against the federal government. Then we have a minor kerfuffle called the Civil War, a little blow up. And as the Civil War was drawing to a close, again, see the movie Lincoln, we adopted the 13th Amendment, which abolished slavery. Then shortly thereafter, we developed, race. Shortly after the Civil War, we adopted the 14th Amendment. 14th Amendment does a couple of really interesting things. Number one, the opening sentence of the 14th Amendment, one of the strangest great statements in history. All persons born or naturalized in the United States shall be citizens of the United States and of the state in which they reside. And one might, if one didn't know the historical background, say, what's that doing there? All persons born or naturalized in the United States shall be citizens of the United States and of the state in which they reside. I'm going to tell you an interesting thing that you probably don't know. That was a sentence written in there to overrule the famous case of Dred Scott against Sanford, a case that was leading up to the Civil War. Prior to the Civil War, Scott brought a lawsuit to have his freedom declared. The details I might talk about some other time. But he brought a suit in a federal court saying, I'm a free man, not a slave. And to get into federal court, we'll come to this again later, he had to say, I'm a citizen of one state, and Sanford, the person who claims to own me, is a citizen of another, so I can get into federal court because of diversity of citizenship. Again, we'll come to that later. But what the Supreme Court said was, incredibly, that no person who is black could be a citizen of the United States, whether he or she was a slave or whether he or she had not been a slave, whether he or she had always been free and had voted and had participated in the Revolutionary War. No black person could be a citizen of the United States, and therefore they could not have diversity jurisdiction. Wild, and really angered many people. So if we have a rule that says no black person can be a citizen, then if we have a new rule, new constitutional principle, all persons born or naturalized in the United States shall be citizens of the United States, there goes Dred Scott, and of the state in which they reside. So South Carolina can't say, we're not going to recognize you as a citizen of the state. Okay, important historically, but it doesn't come up in case law. And then we have the second sentence, which is, again, it's so potent. It says, no person shall be deprived of the privileges and immunities of citizenship of the United States. Erase that. No state, is what I meant to say, no state shall deny any person the privileges and immunities of citizens of the United States, nor take life, liberty, or property from any person without due process of law, nor deny any person equal protection of the laws. So there were three things that states were now forbidden to do. Not take away or deny privileges and immunities of national citizenship, not take life, liberty, or property without due process, and not deny people equal protection of the laws. Three things. But the key is it said states can't do that. So if you remember from just a few minutes ago, the Bill of Rights had applied only against the federal government, was a protection only against the federal government until the adoption of the 14th Amendment, which all of a sudden changed the structure of the government, changed the social contract radically, put a radical set of limitations on the state government, said no state shall do these things, created a lot of new rights, somewhat unclear, new rights. Excuse me, I'll have to erase this. No. Okay. Try again. Okay. Hi, I'm doing a little test again of Dragon to make sure that I've got volume, to make sure that it's actually working. Stupidly, I stopped. So I'm checking. Am I checking? While I am reading this, the computer will adjust my microphone volume settings and then beep to signal that the process is complete. Okay. Hi. I don't think any of that went. Okay, that's right. Okay, excuse me. I was interrupted by a very important phone call in the middle of my discussion of the 14th Amendment, so I'm going to pick up where I left off. No state shall deprive any person of the privileges and immunities of national citizenship. No state shall deprive any person of life, liberty, or property without due process. No state shall deprive any person of equal protection of the laws. This 14th Amendment, by saying no state shall do these things, was intended to and did effectively change that federalism relationship between the central government and the states, because all of a sudden a whole bunch of individual liberties became protectable by the federal government against the states. Whatever was meant originally by these terms, it has turned out that the Bill of Rights, we'll talk about that, which were originally enforceable only or protections only against the federal government, now became, as a result of the 14th Amendment, mostly protected against state governments. Almost all of the rights described in what is known as the Bill of Rights are now things that the states as well as the federal government must recognize. So in our individual liberties portion of our discussion, part 3, the national government, states and federalism, and individual rights, the individual rights part changed radically, particularly with the adoption of the 14th Amendment that made the Bill of Rights enforceable against the states, changed that structure. I'll let it go at that for now, because we'll go into more detail a bit later. But we now have the central government, the states and federalism relationship, and individual rights, and the relationships among all of these. Let's go into it a little further. Let's go back in a little bit more depth this time through. Let's start with the federal powers. The Constitution, first 3 articles. Article 1, the legislative power. Article 2, the executive power. Article 3, the judicial power. That's the order in which these things are put together in the Constitution. But most of the time, people look at this starting with the judicial power. We reverse the order in which they're actually laid out in the Constitution. And you might ask, well, if it's Article 1 legislative, why do most studies of the Constitution start with the judicial power? Answer, one of the critical things, one of the central things in our constitutional system is that it was determined early on that the Supreme Court of the United States would be the arbiter of the meaning of the Constitution and would have the authority to determine that acts of Congress and acts of the President and acts of the states violated the Constitution and were therefore unenforceable. The Supreme Court took this very, very powerful role that it need not have taken, but that it did take. The case is Marbury against Madison. We will come maybe to discussing that a little later, or maybe I'll save it for another class where it comes up. But in any case, the Supreme Court determined early on we have the power to determine constitutionality of the acts of other branches of government, which makes it a good place to start constitutional law, with that body that determines the ultimate meaning of the Constitution. Okay? So, we're going to look at these powers, the power of the legislative branch, the power of the judicial branch, the power then of the legislative branch, and the power of the executive, and the limits on those powers, and the relationships among the 3 branches. That's going to be a major starting point for our discussion. So, federal powers, federal parts of government, the judiciary. Erase that, put a pause in, okay? Another thing about constitutional law, not only are we going to wind up starting with the judicial power, but we are going to spend a lot of time reading different, erase that altogether. Okay, so we said we have this division between the different powers of the federal government, Article 1, Article 2, Article 3, legislature, executive, judicial, but that in fact we reverse the order so that we go to the judicial First, because the judiciary is the branch that has taken on itself and been recognized as having the power to make the ultimate determination of the meaning of the Constitution. The only way the other branches can affect that determination is by doing what the Congress did in the 14th Amendment, overruling a judicial decision by amending the Constitution, changing the language. So that changes the Constitution. A couple of points about what then I'm going to want you to be looking at all the way through our study of constitutional law that are different from what you might be looking at in torts. If you remember in torts, I said torts organizes around torts by fault level, and each tort has a prima facie case, and you learn what must be proved and in what order for the prima facie case and the defenses. That's the way to organize torts. Constitution is rather different. The key thing in the Constitution is to recognize when the Constitution might apply, and that means whenever you see the government acting, the federal government, because the federal government must get its power from the Constitution, and the states, because even though the states don't get their power from the Constitution, the Constitution controls their relationship with the federal government, and the Constitution puts many limits now on the relationship between the states and individuals within the states. So we start locating our dispute in terms of who's involved, federal government, state government, individuals, and that helps us a lot, right? Okay. Second, in terms of this overall approach, locate in the picture, number 2, case squibs. As you read the outline, you will see hundreds, maybe thousands of cases referred to. This is very different from any outline you would see in torts or contracts, where there'll be very few cases referred to. And there are a couple of reasons for that, the most critical of which I think is this. If you're giving a multiple choice test, you have to be comfortable that there is a right answer to the problem. That's why I think constitutional law is not a particularly good MBE subject compared to the others. But many constitutional issues are highly debated, hotly debated. Many decisions come down 5-4. The court is split, and the court changes its composition and changes the direction of its rulings more often than one might wish to see. So to know what the right answer is on multiple choice, you need to know something that's really clear because the court has actually decided it. So Barbry's outline, and any good outline that you might read, is going to contain a number of case squibs describing the facts and stating the holding, and you don't want to try to memorize those, but you want to be aware of all of those so that if they come up, the recognition factor is there. Read case squibs. Okay, third, constitutional law differs from most of the other areas that we study in that what you see throughout the outline is levels of scrutiny. Scrutiny. To scrutinize is to look at, to observe, to look at how am I going to scrutinize this? Am I going to look at it under a magnifying glass so I can see everything? Or am I just going to take a casual look? Levels of scrutiny, and so the outline will be filled with levels of scrutiny. Why? Because if we're saying that the judicial branch has undertaken to decide the meaning of the Constitution, that means the judicial branch, the Supreme Court ultimately, is deciding whether what the actions of Congress, the actions of the President, the actions of various federal agencies, the actions of state governments, whether they are authorized under the Constitution or whether they are forbidden under the Constitution. Now, when judges do this, they have thought about this somewhat carefully over the centuries and said, we can't become a super legislature. We can't look at every piece of legislation that's ever adopted and say, do we think this is a good piece of legislation? Number one, we don't have the time. Number two, we don't have the expertise. We would have to have the kind of hearings that Congress holds. We would have to have different kinds of information than we generally have. So most of the time, in most circumstances, and this goes way back to the beginning of the country, the Supreme Court said, we will presume that what the other branches of government did is constitutional. We will presume constitutionality. The person challenging what the president or Congress or the states have done will have the burden to persuade us that it is unconstitutional. We put a heavy burden on persons challenging constitutionality of the acts of the other branches. That way we don't get too involved in every single detail of what the other branches do. However, increasingly over these 2 centuries, the Supreme Court has said, however, there are some areas of law, some areas of government, where there are reasons why we as judges have some particular function in the system, why we as judges should make independent determinations of whether the legislation is appropriate. And if we decide that this is one of those areas, fundamental rights, suspect classifications like a law that classifies people according to race, fundamental rights, the right to vote, the right to speak, when we find the other branches of government impinging on these limited but very important rights or legislating on these suspect bases, then we have a special burden, we have a special job, we have a special competence. In fact, in a famous case from the early 1940s, Caroline Products, the Supreme Court said, generally for economic regulations, we will employ what is called a rational basis test, and we will say, if Congress, if the state legislature had any rational basis for doing what it did, any reasonable relationship to any legitimate aim of government, then the legislation is constitutional. Only where there's some special reason will we look more closely, scrutinize more closely, and they basically articulated those rights that are expressed in the Constitution and laws that impinge on what they called discrete and insular minorities, whatever that means, people who are separated and don't have as much political clout, and even talked about looking more closely at anything that affected the political process and its fairness in terms of access to voting and so forth. So they said there's certain areas where the judiciary, in order to protect minorities, in order to protect fundamental rights, can put an extra burden on the government to justify what it is doing. Okay? So we wind up with roughly 3 levels of judicial scrutiny with tremendous number of variations elsewhere. Rational basis. For most legislation, whether it's by Congress or the states, economic, welfare, health regulations, the court will defer to the legislature and say that if the legislature had any rational basis, any reasonable relationship to a legitimate aim of state government, then the law is constitutional, and the person challenging the statute has the burden to prove that it's not. Second, we'll jump up to the strictest. If the legislation impinges on whatever we mean by a fundamental right or whatever we mean by a suspect classification, if it's one of those things, then the government, we shift the burden to the government. We say the government must prove that the legislation is necessarily related, not just rational, necessarily closely, very closely related to a compelling governmental interest. Tell us that there is a compelling interest and why, and show us why this law is necessary to that interest. And government has the burden of proof. When that is the case, when strict scrutiny applies, the government almost always loses. And then more recently, the court came up with an intermediate kind of scrutiny. Government has the burden of proof with intermediate scrutiny to prove that the legislation is substantially related, not necessary, not as strong as necessary, but substantially related to an important, not to a compelling, but only to an important governmental interest. But again, the government will generally lose with intermediate scrutiny, which we apply to things like gender classifications and illegitimacy classifications. So that's just a very simplistic view of levels of scrutiny. It's going to turn out that levels of scrutiny, or the approach the court takes, varies tremendously. There are many variations. When we get to the Dormant Commerce Clause, we'll see that when states are burdening interstate commerce, legislation will be held unconstitutional if they unduly burden. So the burden is on the states, or the burden is on the person challenging, however, to show that there's an undue or unreasonable burden, but at least there's some burden of the state to show that they had some justification. So what particular kind of scrutiny we use, we'll see, varies tremendously in different situations. We will also see, as we look at this, that very often answer choices one might have on the multiple choice exam say, well, is the plaintiff's best argument due process, equal protection, or dormant commerce clause? And the way we know this is by really seeing what's the level of scrutiny involved. Plaintiff has to prove no rational basis for due process. Plaintiff has to prove no rational basis for equal protection. But if we apply the Dormant Commerce Clause, then the law will be unconstitutional if it unduly burdens an approach much more, an approach much more generous to who? To the person challenging the statute. Okay? So, locate the facts in the big picture, pay attention to the case squibs, and be acutely aware of the various tests and levels of scrutiny that we will see throughout our study of constitutional law. Next, I'm just going to pick out a few major areas that are tested and are tested all the time that you can be assured you are going to have questions on when you take the bar examination. They're important areas. Number one, looking at federal power. The judicial power shall extend to all cases or controversies, whatever that means, and I'll go into that more later. But one of the things that we see under cases or controversies is, does the person challenging the constitutionality of the behavior have standing? In order to have a case or controversy, we need a person challenging the legislation to be a person with standing. We need the dispute to be ripe. We need it not to have become moot. We need it not to be a political question, a number of things. But standing is the most heavily tested, maybe the most important of the case or controversy concepts. Second, most heavily, among the very heavily tested, always on the exam, federal legislative power. And you will see questions asking which of the following, A, B, C, or D, is the best basis or the most likely basis to support the statute of Congress. On which of the following can Congress pass the legislation? Absolutely going to be tested with several questions every time. Third, the executive branch. What is the relationship between the executive branch and Congress on some of the critical things like the appointment of officers, the removal of officers, and so forth? That's always tested with a couple of questions. Next, moving down to the federalism level of our discussion. In federalism, the single most important set of issues is raised by the Supremacy Clause. The Supremacy Clause says that this Constitution and treaties and statutes adopted thereunder, under the Constitution, shall be the supreme law of the land, anything in state law notwithstanding. Which means, if there's a clash between federal and state law loses, federal law controls. Supremacy of the central government is a key to the whole system. If, in fact, states were free to ignore federal law, then we would not have anything like our present nation in terms of the cohesion, more or less, of our nation. Second big federalism concept, the Dormant Commerce Clause. And again, we'll come to this in somewhat more detail, but there's this concept that by granting the power to regulate commerce between the states to Congress, by giving that power to Congress, implicitly states are limited in what they can do with interstate commerce, even if Congress has done nothing. That's why it's called dormant, or the sleeping commerce clause, or sometimes referred to as the negative implications of the commerce clause. If the Constitution does, as it does, gives power to regulate commerce to Congress, by implication, if Congress has not acted, if Congress has acted, then it controls under the supremacy clause. But if Congress has not acted, states are still implicitly limited by the grant of the power to Congress. That's the concept of the dormant commerce clause. Again, we'll come to it more later. The full faith and credit clause, a clause in the Constitution that says that each state must give, whatever this means, full faith and credit to the acts of other states. A judgment in state 1 is enforceable generally in state 2. I go to state 1, I sue somebody in state 1, I get a judgment. That person has property in another state, I take my judgment, I go to the other state. The other state generally, roughly, has to enforce my judgment. They have to seize the property or whatever I'm entitled to. The full faith and credit clause. Where was I? Okay. Also, in the federalism area, also in the federalism area, the due process clause, which I mentioned is part of the 14th Amendment, imposes limits on what states can do in relationship to other states. This is something that's mostly taken up in courses in federal procedure or civil procedure, but be aware that the due process clause imposes some limits on states that we may talk about later. There is also, in the main text of the Constitution, a privileges and immunities clause that says a state cannot discriminate against citizens of other states, which has been interpreted to mean discriminate only to natural citizens, doesn't apply to corporations, doesn't apply to aliens. But if the state is discriminating against actual citizens of other states as to whatever the fundamental rights that they have found protected are, then the state cannot do it. So that's a protection that involves the relationship between the states as well as individual rights, kind of mixed together. Next, in terms of the relationship between the feds and the states, what if the feds have a regulation or a taxation on a state government? Can they do so? What if the states have a regulation or taxation on the federal government? Can they do so? Supremacy clause, no, they can't. We'll have to go into that in somewhat more detail, but these are always tested, always going to appear on the exam. So a certain number of areas you can be assured of having appear on the exam. Now, we go to our third big area, individual rights. What do you need to be expecting? Well, number one, you need to understand that with only one caveat, the individual rights protected under the Constitution, Bill of Rights and elsewhere, are only protected against the government, not against private people. Federal government under the Bill of Rights, state governments under the 14th Amendment, we need state action. Before we can claim that there's been a violation of freedom of speech, a violation of freedom of religion, before we can claim that, we must say that the person who's doing the deprivation is the federal government or the state government or somebody who is so intertwined with our federal or state government as to make this the action really of the state or the federal government. We need state action. We need to be aware of that and understand it, and it always appears. Number two, in terms of things that always are going to come up, in the original text of the Constitution, there are several little clauses that do not come up very often in real life and don't come up really often on the bar exam, but are often there, often as appealing wrong answers. The Constitution says that neither the states nor the feds shall pass ex post facto laws, whatever that means. The Constitution says that states and feds shall not pass bills of attainder, whatever that means. The original Constitution says that states shall not pass laws impairing the obligation of contracts. That's a rule that applies only against the states. In general, those rules, those individual rights, are not coming up often on the MBE as correct answers, but they can, but they're very often there as tempting wrong answers, so it's important that you understand what they are to know whether they might apply. Now, in the Bill of Rights, there are many things, but I want to talk about one in particular that doesn't deserve a whole section, but always appears. There is a clause called the Takings Clause, enforceable against the United States because it's in the Constitution, Fifth Amendment. Enforceable against the states because somehow or other it comes in through the 14th. We'll talk about that later. The Takings Clause says that the government shall not take private property for public use without just compensation. So what exactly that means? What is a public use? What is a taking of private property? And what's just compensation? Those are complex questions, usually one question on the test. Then, another thing you can be assured of seeing in general, the Bill of Rights, other than the Takings Clause, the First Amendment and so forth, protected against the feds originally, but as a result of the 14th Amendment, for reasons we'll talk about in more detail later, protected against the states. Always going to be tested, 13th, 14th, 15th Amendments as protections of individuals against the states. Okay, in fact, let me take a moment on that. When the 14th Amendment was adopted and Congress put into the amendment the phrase, "No state shall deprive any person of privileges and immunities of national citizenship, nor due process, nor equal protection," those three, it is almost certain that the purpose of the Privileges and Immunities Clause, the first clause, was there to say now those things in the Bill of Rights, freedom of speech, freedom of religion, freedom from having one's property taken without just compensation, should now be enforceable as privileges and immunities against the states. However, the court, being the body that interprets the meaning of the Constitution, determined, in its view, in cases called the Slaughterhouse cases, that the privileges and immunities of citizens of the United States should be narrowly interpreted to mean only those privileges that one has only because one is a citizen of the United States. Things like the privilege of petitioning your congressperson, of traveling to D.C. to petition your congressperson. Very narrow, and therefore never, until recently, the basis for any law to be invalidated. What the history of this was and why exactly the court did this, we can leave aside, but I believe it's pretty clear that the P&I clause was intended to make the Bill of Rights enforceable against the states, and the Supreme Court made sure that it didn't. However, over the next 150 years or so, what the court did was it found that the Bill of Rights, or most of the rights protected in the Bill of Rights, were enforceable against the states on a theory that they were incorporated in the Due Process Clause. So rather than using the P&I, Privileges and Immunities Clause, which seemed an obvious way to make those things enforceable against the states, instead, one by one, over a period of many decades, the court found that freedom of speech was incorporated in the concept of due process. Freedom of religion was incorporated in the concept of free exercise of religion, and so forth. This concept of incorporation, something we see all over the law. I write a will and I refer to another document that already exists that divvies up my personal property, and I refer to it and say that's what I want to have happen. The doctrine is called incorporation by reference to the other document. So basically what we're talking about with the Due Process Clause is a concept that the courts have found that the concept of protecting due process incorporates freedom of speech, freedom to exercise your religion, freedom against the establishment of religion, and most of the rights contained in the so-called Bill of Rights. It does not include, it does not incorporate, as of this moment, just a few things. It does not incorporate the right to a grand jury. Only in federal courts do you have a right to a grand jury. It does not incorporate the right to a civil jury trial, only to a criminal jury trial. Does not incorporate the right to no excessive fines, but very little that's in the Bill of Rights is not incorporated through the Due Process Clause. So expect to see answers that say plaintiff or defendant wins under the First Amendment as incorporated under the Due Process Clause of the Fourth Amendment. That's referring to this process that took place over decades of the court recognizing the enforceability of these rights against the states by finding they were incorporated in the Due Process Clause. Okay? Now, we have our 13th, 14th, and 15th Amendments, and we have due process expressly mentioned and equal protection expressly mentioned. And since privileges and immunities is pretty much wiped off the books by the slaughterhouse cases, what big things are we going to see in due process and in equal protection? Due process. Due process sounds like it's talking about process, procedures. You should get fair procedures. And in fact, a substantial number of the decisions under the Due Process Clause are talking about what procedures are in fact due. That's what has become labeled as procedural due process, the process that is procedural. Kind of crazy, but that's one area of due process law. Second area of due process law is Due Process Clause as incorporating most of the Bill of Rights. The third area under due process is what has been labeled for about over 100 years substantive due process, not procedural, but substantive process. When can we find, we being the court, find that what a state or what the federal Congress has done violates due process? Well, either because the person was not given fair procedures by a neutral and detached magistrate, or because as a matter of substance, there was involved in the area of legislation a fundamental right, and the legislation denied people that fundamental right under the Due Process Clause. So that's due process, three different areas: procedural due process, incorporation, and review for fundamental rights under the notion of substantive due process. Our second big area is equal protection in the 14th Amendment, and that's where we get categorization of people. That is to say, the Equal Protection Clause says states shall not deprive people of the equal protection of the laws, but of course almost any law deprives people of equal protection in some sense. Anybody who robs a bank shall go to jail for 20 years. That's treating or bank robbers differently than it's treating non-bank robbers. And in fact, it may treat bank robbers differently than it treats people who just commit a minor larceny or shoplifting. So we're classifying people, we're treating them unequally. So what do we do with the Equal Protection Clause? Basically we say, we the court, we as courts say, we will defer to the legislature for most classifications. But if the legislature classifies people in one of those areas where we think it's particularly inappropriate, or where we think it's particularly risky, or where we think that the judiciary has some particular competence, then we will apply that higher level of scrutiny that I talked about earlier. And what are the categories where equal protection will apply a higher level of scrutiny? There aren't that many. Race, any classification according to race. Nationality, classification according to is he Japanese or not Japanese. Or alienage, are we classifying people according to whether they are citizens or whether they are not citizens? They are all entitled to strict scrutiny, as I mentioned earlier. Next, if people are classified according to gender, male, female, or according to illegitimacy, whether their parents were married when they were born or their parents weren't married when they were born, then we will apply what I called earlier intermediate scrutiny, a somewhat lower version of scrutiny, but not rational basis. Third, in addition to the race, nationality, alienage, strict scrutiny, and the gender and illegitimacy, intermediate scrutiny, basically the court has said, as to everything else, as of this moment, everything else is tested in terms of whether the classifications are rationally related to a legitimate aim of state government, in which case we defer to the legislature. So that's basically what we're doing with equal protection, applying one or another level of scrutiny depending on what kind of classification we have. More on that later also. Now, in addition to the basic rules of due process and equal protection, you will see a tremendous amount of law under the freedom of speech. That will be something very heavily tested on the bar because it's very critical. First Amendment, freedom of speech. Congress shall not deprive citizens of persons of freedom of speech, whatever that means. So what does it mean? There are a couple of concepts under freedom of speech that you can be assured will appear on the exam. Number one, regulations that pertain to speech cannot be vague, they cannot be overly broad, and they cannot allow for unfettered discretion, whatever that means, by the police, and they're more likely not to be upheld when they involve a prior restraint. So speech, when the regulation is vague, overbroad, discretionary, or involves prior restraint, are likely to be found unconstitutional. That's obviously an oversimplification. Second, in addition to these general concepts, we're going to divide most of the discussion of freedom of speech into two kinds. Number one, speech regulations that incidentally affect speech, but that are basically regulations of the content in which the speech occurs. Okay, I'm walking on a picket line carrying a sign to communicate a message, but my message, don't vote for Obama, don't vote for Romney, or do vote for them. My message is mixed in with the conduct of picketing. If Congress or the states are regulating conduct, then we apply a lower level of scrutiny than we do if they are regulating directly the content of the speech. That makes sense, right? The concept of freedom of speech is mostly to do with the content of speech, not with the physical methods of carrying it out. So the general rule is that conduct regulations must be neutral, and if they are neutral, then neutral time, place, and manner regulations, then they will be upheld if they are narrowly tailored to an important governmental interest and leave open alternative methods or ways of communication. That's a kind of intermediate scrutiny. Content neutral time, place, and manner regulations will be upheld if they are narrowly tailored to accomplish an important governmental interest, and they leave open alternative avenues of communication. Sorry, I tripped up my words a little bit. However, if the regulation is content-based, you may not speak about politics in this location. You may not speak about religion in this location. You may not threaten people. You may not use words that are false and misleading. Regulation that has to do with the words that are said or the content of the communication. You may not burn flags. Well, let's leave that out for now. Content-based. Then generally we're going to apply strict scrutiny because this is the essence of what the First Amendment is there to protect. Speech. And now we have a regulation based on the content of the speech. So we're going to apply strict scrutiny, except what has evolved over the last 40 or 50 years, if the speech is, quote, unprotected. That doesn't get the full protection of strict scrutiny. And there are simply a few categories to which this applies. Number one, based on growing out of a famous old case in which Oliver Wendell Holmes, Justice Holmes, said that freedom of speech does not mean that one is entitled to falsely shout fire in a crowded theater. Because by falsely shouting fire in a crowded theater, you are threatening imminent death to the people who might be trampled. This has evolved into the concept that if what a person is doing with his speech is inciting imminent lawless behavior, that speech is not protected. Number two, if the speech that is prohibited is what are called fighting words, the kind of words that lead to reactions that cause immediate fights, then that is not protected. Number three, obscenity, whatever that means, is not protected. Number four, defamation is not fully protected. Defamatory speech is subject to some restrictions but is not fully protected. And finally, in the list, commercial speech, false and misleading speech for the purposes of selling things, not fully protected. That's it, right? So our basic structure for the First Amendment, we have to fill in lots of details, but our basic structure is, number one, we have these general concepts that speech shouldn't be vague, overbroad, allow for discretionary enforcement, or involve a prior restraint. Then, if we get past those general concepts, we have to consider, do we have regulation of conduct or regulation of the content of speech? If we have content neutral regulation of conduct, time, place, and manner, as it is called, then it will be upheld if it is narrowly tailored to an important governmental interest and leaves open alternative avenues of communication, a kind of intermediate scrutiny. But if the regulation is content-based, then we will apply strict scrutiny, except if the language is unprotected, for which we have these categories: incitement to imminent lawless behavior, fighting words, obscenity, defamation, and some commercial speech. That is summarizing a whole lot of very complex law, but in a way that I think now everything can fit on that structure. In addition, you will probably have a question in which you need to know that even though it's not expressly there in the Constitution, by implication, the First Amendment protects the freedom of association, freedom of people to associate with each other without being punished for who you choose to associate with, and freedom of the press, which is no more than everybody has, but raises some unique concepts, or comes up in some unique concepts, so be aware of the concept of freedom of the press. And we finish that whole law of the Constitution with religion. We're not allowed, Congress is not allowed, nor are the states allowed to interfere with the free exercise of religion, nor may they establish a religion. Okay? And you are likely to have one question on the rules of free exercise and one question on the establishment of religion. That's the whole of the major areas that are tested. Others details, but that's mostly what's tested. I'm going to stop now because in the next hour I'm going to go through in some more detail some of the important points. Some of the more important stuff I'll save for when it comes up in relationship to specific fact patterns, but I think it's worth taking some time on some of the major points to go into some more depth in this introduction. Thank you. Oh, God. Oh, my God. Whoa. Wow. Huh? Huh. Wow.